The case of Loh Kui Chun against the government of Malaysia. Facts of the case. In this case, the plaintiff is Loh Kui Chun. The defendant is the government of Malaysia. Warrant with provisions of restricted residence enactment issued for plaintiff leading to his arrest and detention. Appellant was not produced before magistrate within 24 hours of arrest, of which he claimed damages under the right of habeas corpus in Article 5, Clause 4. No action was held towards the police officer as he acted according to the warrant provided. The appellant appealed, but before the appeal was heard, the Constitution was amended stating that Article 5 Clause 4 would not apply to arrest or detention of person under existing law relating to restricted residence. The constitutionality of this amendment was argued upon.
Issues of the case. Questions to ponder. Was the amendment of the law unconstitutional? Whether the amendment of Constitution with retrospective effect is valid. Applied rules. Article 4, Clause 1 of the Federal Constitution. Any law passed after Merdeka Day is void, but it is not pertinent to this case as it does not apply to the Constitution itself. Article 7 of the Federal Constitution on the retrospective effect of the constitutional amendment. Article 5, Clause 4 of the Federal Constitution allows the detainee the right to be presented before a magistrate within 24 hours of detention. The residential residence enactment was applicable as the grounds of arrest. The basic features doctrine applied in the Federal Constitution is respected in this case.
Ratio decidendi. 1. The Parliament has the right to alter the fundamental rights in the Constitution as long as the procedure is consistent with Article 159. 2. The Impeachment Act was constitutional. 3. The main role of the courts is to interpret the provisions of the Constitution, albeit deemed harsh or unjust by the citizen. Analysis. Article 5, Clause 4 states that a person arrested must be taken before magistrate within 24 hours so that an independent authority exercising judicial powers may without delay apply its mind to his case. This safeguard is to a large extent covered by the provisions of the Criminal Procedure Code, but its incorporation in the Constitution is deemed essential. 1. Assure the minorities that their rights would be constitutionally guaranteed. 2. They shall not entertain any apprehension of the alleged despotism and arbitrariness of the majority and legislative omnipotence. This safeguard equally applies to any person arrested under the Restricted Residence Enactment, Cap 39. See Asa Singh against Menteri Besar Johor, case law. But evidently difficulties have arisen in the practical application of the enactment and hence the need for the amendment. As fundamental rights are not equivalent to ordinary rights, they can only be suspended or abridged in special manner provided in the Constitution. The judge felt that the purpose of enacting written constitution is partly to entrench the most important constitutional provisions against repeal and amendment in any way other than by a specially prescribed procedure. The reasoning for the judges, Raja Azlan Shah, federal judge, view is based on the premise that the Constitution as the supreme law, which is distinct from ordinary law and it cannot be inconsistent. If the Constitution is to urge to be on the same level as ordinary law, then the Constitution is an absurd attempt on the part of the framers to limit a power in its own illimitable nature.
Article 160 Clause 1 stated that law made in exercise of ordinary legislative power and not made in exercise of the power of constitutional amendment under Clause 3 of Article 159, with the result that Clause 1 of Article 4 does not affect amendments made under Clause 3 of Article 159. As far as an Act of Parliament is concerned, and in order to determine whether it is retrospective in the case, the language of the Act itself must be looked into, taking heed that an Act is not to be construed retrospectively unless such intention was clearly stated by the Parliament. If the Act has retrospective effect, even in respect of substantive right or pending proceeding, the courts have no alternative but to give effect to the Act, even though the consequences might appear harsh and unjust. The principle that parties are to be governed by the law in force on the date when an action is instituted, and any subsequent amendment or alteration cannot affect vested right or pending proceeding, must always be read subject to the corollary that Parliament can always expressly provide that vested right or pending proceeding be affected by the amendment of the law. Court holding. Constitutional provision must always operate prospectively and not retrospectively unless retrospective intention was clearly intended in the provision. The imposed charges was valid even though it was deemed harsh and unjust. The amended act was accepted and the case was dismissed by the court. Thank you for watching.